All persons having business before this court will draw near and give their attendance, and they shall be heard.
Thank you. Please be seated.
Oh my God. Move this chair. Oh my gosh.
Good morning, everybody. I'm Presiding Justice Gerald Whalen. And let me say, and begin by saying how wonderful it is to be back with the members of our court in Syracuse in person in this magnificent courtroom. Today's panel members are Justice John Centra from Syracuse, Justice Aaron Perodato from Buffalo, Justice Stephen Lindley from Rochester, and Justice Patrick Niemoyer from Buffalo. We also have with us today in the audience Justice John Curran from Buffalo and Justice Joanne Winslow from Rochester. I would like to publicly thank Administrative Judge James Murphy and District Executive Don Doerr, who's in the back, for their invaluable assistance in making today's session of court happen. When you serve on the appellate division, you understand that the decision and decisions you issue will likely be the final decision in the case, because in over 90% of the cases we handle, there is no appeal to the Court of Appeals. We are, in those many cases, the court of last resort. And that puts an extra burden on our justices to put forth the maximum effort in order to reach the correct determination. We all realize our work is very important to the litigants, the attorneys, and the public in general. In order to serve as an appellate division justice, you have to give up some things. You give up control of your personal and court calendars. You can't schedule personal or family days off or vacations when you want to, because it's the court's docket and the court calendar that takes priority. You have to agree to work weekends and holidays. You agree to travel away from home for 2 weeks out of every 6 weeks and give up the comforts of home life for life in a hotel and living out of a suitcase. And you give up being the final sole decision maker in your court, and you agree to being one of 5 negotiating, sometimes struggling, to reach a joint decision. Many judges look at the appellate division and decide not to make the jump because they would rather stay on the trial bench, and that's fine. Those that do come to the appellate division do so knowing full well the extra work, time, and stress on your family and on yourself that is involved. These jurists that I'm about to mention have made those sacrifices for themselves and their families, and have done so for many, many years. Without the sacrifices made by our appellate division justices, including these 3 fine jurists, the vitally important work of our court would grind to a halt. We, as a court, would have been significantly diminished had Justices Centra, Carney, and DeJoseph decided not to make the necessary sacrifices. The Fourth Department has, for the past 8 years, been very fortunate to have these 3 members of your community sitting on our court. Recently, Justice DeJoseph left us for retirement and to spend more time with his lovely wife, Stephanie, who is here in court with us today, and other family members, especially those grandchildren. And also with us today, I understand, is Justice DeJoseph's daughter, the Honorable Christina DeJoseph. Is she here? She's working. She's working. Okay, well, good. We'll keep her working. Justice DeJoseph contributed to our court in many ways. His scholarship was always thorough and reliable. His willingness to really listen to his colleagues' point of view was genuine, and he never said no when called upon to take on additional duties, which was often. On behalf of myself and the justices you served with, I would like to publicly thank you for your valuable service as a member of this court and your friendship throughout the years. Justice Edward Carney was a member of the court when I joined it. He served approximately 15 years on the appellate court, beginning in the second department, but luckily for us, the great majority of his appellate time was in the fourth department. Justice Carney's writings, whether it be opinions, mems, or reports, were always a pleasure to read. His workmanship, the detail and thoroughness of his appellate writings were highly respected and relied upon. Justice Carney had a well-earned reputation and a respect of his fellow justices and the entire court staff. You could always talk to Justice Carney about the cases you were working on, and he would soon focus in on the important controlling issues to be decided. His mind is very sharp and logic-driven, which are not bad attributes for a judge or a lawyer. He was and is my friend, and is a friend to all the justices he served on our court. Justice Carney left us to resume his work in private practice, and on behalf of the entire court, I wish Justice Carney and his wife Sula the best of luck in this next chapter of their lives together. So, the Syracuse boys, that's how Justice Perodato refers to them. So the Syracuse boys, Justice Sentra, Carney, and DeJoseph will soon be all gone from our court. Once today is complete and the cases are heard, it will be the end of an era, an impressive era of influence on the Fourth Department by justices from this community. They helped shape the common law for our department and the entire state of New York. Today is the last sit of Justice John V. Sentra. My wife Nora reminded me that it was Justice John Sentra that first welcomed us to the court. He was the first justice to greet her and my boys just prior to celebrating my first sit. And that is who Justice Sentra is. He has been there to offer encouragement to all of our new justices and a warm welcome to their family members. Justice Sentra knows well the difficult work required of an appellate division justice and the need for a supportive home and work environment. Justice Sentra has always been there if a colleague needs guidance or advice, needs to vent, or simply share a concern. Justice Sentra is always looking out for the court. It is his top priority. The question, what is best for the court? Well, the answer to that question is always and always has been his North Star. I would be remiss if I didn't recognize Justice Sentra's wife, Mindy, sitting here in the front row, and some of his other family members in attendance. Their daughter, Nikki, is sitting in the front row also. Their granddaughter, Lexi, is here. Their son, Assistant District Attorney John Sentra, is here at the end of the row. Justice Sentra's brother, Dino, is here. And their son, Dino, and Kathy's son, Joseph, is he also here? Joseph's working. Joseph's an attorney at law also, keeping busy. And finally, Justice Sentra's father, Dino Sentra Sr., is here. Now, speaking of John's father, when I first came to the appellate division, I learned about Justice Sentra's dad. I was told he was a successful businessman in the Syracuse area. He is very well thought of and respected, I was told. Well, Mr. Sentra, the apple didn't fall far from the tree. Your son John has carried the family name beyond Syracuse and Onondaga County in the 5th Judicial District with honor. He is known as a well-respected jurist in the entire 22 counties of central and western New York and the entire state of New York. He is one of less than a handful of current appellate division associate judges in the entire state of New York to have been asked by the chief judge of our highest court, the Court of Appeals, to sit on the Court of Appeals and hear a case. It is, I think, the highest honor an appellate justice can receive. He received that honor because of his excellent reputation as one of the most distinguished judges in our entire court system. Mr. Sentra, you and your entire family should be very proud of your son John and his accomplishments. John, you'll be dearly missed, as much for your thoughtful participation during conference and the disposition of cases as for your ability to keep the court collegial and a pleasant place to work. On behalf of our supremely talented staff, the court members, and the legal community, I say thank you for your dedicated service, and we all wish you well in the next chapter of your life.
Thank you. This is probably and by the way, these speakers that are here aren't so you can hear us better. It's because everything we do is recorded, so as a general rule. I want to thank the presiding Justice Whalen for those kind words. I won't make a joke of it like I did last week. And I'd like to thank him for bringing the 4th Department to Syracuse for my last sit. And I'd like to thank my colleagues here and out there and former colleagues for being here today. Last week I was able to address my Rochester family. So if you don't hear me mention them today, it's not because I don't like them, it's because I don't want to repeat myself. Today's remarks will be intended for my Syracuse family. My 4 kids, Nikki, Stephanie, Johnny, and Jake, all of them have made me so proud in their special way. There's many dinners, nights, and sporting events without me being there while pursuing my career. They seem to know and understand at a very early age why I wasn't around and as much as I should have been. They've always supported me and helped me get to where I am today, and I'd like to publicly thank them for that. I have a special shout out today to my favorite granddaughter, Lexi, and now, as of today, my 3-week-old favorite grandson, Kane. I love you both. As to my legal accomplishments, I had a lot of help. Mr. Langen got me thinking of becoming a lawyer and was there for me in my early years. Then came the DA's office. John Sarando was instrumental in getting me the job there. When you begin working in the DA's office, you start in the appeals unit, which was headed by John Sarando. I lasted 3 days. Then he sent me to city court. 16 years ago, when I started in the appellate division, I took great pleasure in asking him questions when he was arguing one of his appeals. As John would say, payback is a, okay? While in the DA's office, John LaParle became my boss, mentor, and friend. John mentored many of the successful attorneys in this community here today. He recently passed away, and many of us lost a great friend and a mentor. John, may you rest in peace. After the DA's office, I was fortunate enough to become a law partner with Judge Carney and Judge Rose, who joined the firm. And boy, do we have a lot of fun. And thank God the statute of limitations has run. That's part of it. Okay.
It's your day. However you want to do it.
Okay, I think I missed it. Okay.
That's it. Go back.
I never thought I'd do this. I've accomplished a lot in my life. I'm probably an overachiever. But make no mistake about it. Did I do this?
No.
I had a lot of help along the way.
It might be time to leave.
Okay. My mom, who is no longer with us, my dad and brother Dino have always been there for me from the beginning. No problem was too big or small for them when it came to me. The work ethic they instilled in my early years has played a major role in my success. I'd like to thank my mom, my dad, and my brother Dino. Now I'll get back to where I meant to be. After the DA's office, I was fortunate enough to become a law partner, as I said earlier, with Judge Carney and Judge Rose, who joined the firm. And as I said, the statutes run, so we won't repeat that. I then moved on to the Primo Law Firm, and Dave Primo, now the Chief Family Court Clerk in Onondaga County, is doing a fantastic job. I was fortunate enough, again, to join and work with Judge Carney, not only at Supreme Court, but also at the Appellate Division. All I can say is the Appellate Division was well represented in Syracuse with Judges Carney, DeJoseph, and myself. This morning, when I was thinking about this, it dawned on me that between the three of us, we have in excess of 90 years of judicial experience, and it's a huge void that's going to have to be filled, but I was proud to serve with both those jurists. While at the Appellate Division, I had many mentors who passed on invaluable institutional knowledge to me that I've tried to pass on to my newer colleagues. I've been fortunate to have an outstanding secretaries. Pam, who's with us today, was with me for a number of years, was outstanding, and now she's working in city court. They gained someone invaluable. And I was fortunate enough in the interim to have Erica, who'd worked for Judge Carney, to finish her career with me when I finished my career, and I'd like to thank her for outstanding work and her dedication to me, Erica. Last week, I recognized Colleen Farrell, my law clerk, for her work and dedication to me. Those of you who really know me know just how good she makes me look. I could not ask for anyone better than her. I'd like to recognize three people who are no longer with us, but who were instrumental in my political career: Bob Geruso, J. Patrick Barrett, and Jack Cookfair. Last but not least, my wife, Mindy. My wife has been a major part of my success. Anyone who knows me wholeheartedly would agree with that statement. From May 13th in 1977, when we first dated, until today, Mindy has never wavered in her support of me and my career. Many nights she was the only parent. Some people thought she was a single parent because they never saw me. She did all this so I could pursue my career. Any accomplishments or recognitions I've received truly belong to her. The successes of our 4 children and how well they've turned out was mostly her. I wouldn't be up here today without her, period. I'd like to thank those who came here today. May God bless this country, and may God bless you. I promise you I won't make the same mistake on your case.
Okay, so this is a good opportunity for those that have come for the, just the ceremony. If you wanted to leave, by all means, feel free to do so. We're going to start the calendar and the calling of cases now and the hearing of arguments.
You know, when I got to that first line, I got emotional, and I forgot that paragraph. I mentioned my brother, my dad.
You did a good job.
I screwed up. Come on, let's go.
Okay. The first case on for argument today is case 736, People versus Griffin. Counsel, it looks like you may be alone.
May it please the court? Presiding Justice, Justice Sentra, and the Justices presiding. Evan Eswine on behalf of Respondent. I want to take advantage of my captive audience, but if there's any questions, I'd be happy to respond to them. Otherwise, it's the people's position that the county court properly denied the recusal motion. There was no violation of the judiciary law, as well as the motion to recuse our office.
Very good. Thank you, counsel.
Thank you.
Case 738, People versus Kenny.
May it please the court, Peter DeGiorgio for the appellant. Before I start, I just want to congratulate Justice Sentra. It's truly been an honor and a pleasure to appear before you and to argue before you, and I'm going to miss the insightful and direct questions. Oh, maybe not. But you've really been a mentor to me, and I wish you the best in all of your endeavors. I'm going to primarily focus on points 2, 4, and 5, and I'm going to comment on point 1 with respect to this case. Point 2 deals with an issue of what I thought was very prejudicial testimony that came in from the camp manager, Cheyenne Mary, who testified to a prior encounter she had with the defendant that was very similar to the encounter which was the basis for this rape charge. There was no
I know what you're about to say. There's no Molyneux. I wonder if that evidence was really even Molyneux evidence.
I think you can infer the statement that came in and was emphasized by the prosecution. He can do what he wants, is what the defendant said.
That could be eaten like cheeseburgers and french fries. I mean,
It could be
what?
read as he could do what he wants, meaning he's separated from his wife and he can have an affair with this woman. It could mean that he could do what he wants sexually with her. But why is the prosecution bringing that evidence in if it's not for the implied belief that he's making that statement because this is his modus operandi to bring women to this cabin and to have sexual relations with them? And I think he was entitled constitutionally to a hearing to determine what's the probative value of that, which I would think would be very little, and what's the prejudicial effect. The prosecutor made it a point of bringing it out twice. There was an objection to it the first time, and then the objection was overruled and it was brought back again. I'm sorry, Judge, did you have a follow-up or?
no.
Okay.
No, because you made my point.
So I think that the probative value of that was very nominal. There should have been a Molyneux hearing on that, and it should have been excluded. And I cited case law, which stands for the proposition, when you're dealing with a case that evolves or is determined upon the victim's credibility, which this case was, there was very little corroborating evidence.
Well, there was DNA evidence.
Well, the DNA evidence was touch DNA evidence, which was found on the waistband.
Didn't that corroborate her statement that how he did it and relative to her sweats, and then the DNA was found there? I mean, it's some form of corroboration to her statement.
The fact that he sat next to this woman and touched DNA was on the waistband of these sweatpants, I think is insignificant. I think what's more
I
important...
thought her testimony was that at the time, he reached up, grabbed her sweatpants and pulled them down, which would put his DNA at her waistband.
Correct, but his DNA could have gotten on her waistband from him sitting next to her at the same time. What's more significant
It
is...
doesn't make it non-corroborative. It just makes, it's just another explanation for how the evidence got there. It doesn't mean that that evidence doesn't corroborate her testimony.
Right, but I think we have to balance all that evidence in looking at it in the context of what other evidence was there other than her statement that this rape occurred, in the context of whether should we look at the prejudicial effect and whether or not we could use harmless error analysis for the point 2. I mean, I'll agree, and this is why I didn't focus on point 1 of my brief in the oral argument initially, is that, you know, to overturn on the weight of the evidence when you have the victim's testimony is a very high hurdle. I mean, there was other DNA of unknown origin found in the crotch part of the panties, but
That was
again,
also consistent with her testimony also.
I'm sorry, that was what?
The other DNA was also consistent with her testimony.
Right, but you would have think that the DNA of the boyfriend would have been not of an unknown person. In any event, it's in the context of there wasn't a lot of solid corroborating evidence that we could then just totally throw out the harmless error analysis for the lack of having a Molinol hearing. The next point I want to touch upon is the sentence, and I seem like a broken record. Those of you
Here yesterday.
who saw me yesterday, I was making the same argument, but this time I do have the record does reflect what the what the offer was. He was offered 7 years, and he went to trial and got 18 years.
Yeah, but didn't the court acknowledge the fact that it had learned more about the case as it went forward?
I don't know what more there was to learn about the case. I mean,
Some of his statements, what he said to her during the act, what he said to her driving her back to the campsite?
possibly, but is that enough to impose a 2.5 times penalty than what the plea offer was?
And that's something that we have to take a look at. I mean, the idea of, a penalty for going to trial is something that we're well aware that we have to look at, and that's part of the argument here. The court certainly knew at the time that offer was made initially before the trial, that this was a rape case, knew that this was a serious case, and yet that sentence was offered.
And I understand, and you, Honors, in past cases have told me that when the victim has to testify, that's a factor that the trial court can utilize, and there's case law to support that.
It wasn't just that she was forced to testify. She also made a powerful statement at sentencing, which is something that the court didn't have when the plea was being discussed.
True, but also, Your Honor, he showed remorse at the time of sentencing. He doesn't have any prior criminal history, and I think the probation report, except for the rape charge, was a generalized favorable document. I'll rely on the brief with the rest of my points, including the weight of the evidence. I think we touched upon that in the oral argument, in the first part of the oral argument. Unless the court has further questions, I'll rely on the remainder of my brief.
Thank you, counsel.
Thank you.
May it please the court, Michael Johnson from Herkimer County for the people. I'll start with point number 2. I just want to emphasize, as the court knows, that this issue was unpreserved. Counsel did not object to that question. He objected to a question, but on other bases. In the people's opinion, there wasn't anything immoral or criminal about the conversation that went on. It was a normal part of the training process, one showing the cottage. I understand that they got into a conversation which...
But the other argument is that it was irrelevant, and...
It might be, but I think in that case...
Harmful.
It might be up to counsel to object to that. I think it was such a close call...
That's part of his ineffective assistance of counsel argument.
Well, but I think there was a clear trial strategy in that regard. The trial counsel attacked the veracity of the victim and the DNA evidence. He centered on that. And so that he didn't make an objection to this evidence, I mean, I can't get into his mind, but that might not have been his strategy to do.
He could have objected and still pursued those other strategies that you spoke of.
I agree he could have, and I cannot speak for what he did or didn't do, but I think the point is it's a close issue, and that he didn't make that objection now doesn't necessarily make it ineffective assistance of counsel. I'll touch on the harsh and excessive sentence. The offer was, I believe, 7 and 20, 7 years imprisonment, 20 years determinate. The sentence that he got was 18 years determinate, but only 10 years post-release supervision. So the court did modify that down.
What evidence came to light at the trial that the judge wouldn't have known from the review of the grand jury minutes, which I presume that the victim testified to grand jury, didn't know prior to trial? What's new that justified going from 7 to 18? We all understand that if a defendant turns on a plea bargain, there's going to be, that sentence is probably not going to be available after trial. But here to go from more than double, 2.5 times the sentence, it does on the surface appear to be a trial tax.
Well, Your Honor, what I would say to that is I think the grand jury testimony would be in some ways different, more impactful at trial, especially for the victim. And the victim having to face her accuser and testify in front of a jury, that is all things that are, I think, a court would take into account. Also,
Let me ask you about that, counsel. The fact that the judge has the testimony, presumably from the grand jury, and knows what occurred, the fact that we now have a trial person testifying, should the emotional component of live testimony be driving the judge's sentence?
well, I think, I don't think the trial testimony was the only thing that was there. Certainly the sentencing, reading at sentencing from the victim, I'm sure that played a role, but I want to emphasize too, this sentence was well within the guidelines, right?
Well, yeah, that's not in dispute, but the judge and the prosecutor agreed prior to trial that a 7-year sentence would be fair and appropriate, given what happened, given the defendant's record, given all the facts and circumstances. And then he elects to go to trial, he ends up with 18, and we're asking what's changed, other than the fact that he exercised his right to trial.
Well, I think the offer was also based on, not having the victim have to go through that ordeal. I mean,
That usually plays a major role in criminal cases, in sex cases, when the victim, depending on the age, has to be brought in a courtroom in front of strangers and testifies. But you have to recognize, when we're looking at something like this, it is a big jump from 7 to 18. It isn't 7 to 12, 7 to 14. It's more than double.
I recognize that it is.
We'll look at that.
It is a jump, but it is well within the guidelines. And just to finish up, in regards to legal sufficiency, I think there's more than sufficient evidence when viewed in the light most favorable to the people. Contrary to what the defendant would say, I think the testimony was credible. I think it was consistent. She agreed that she was intoxicated, although she never said she was severely intoxicated, as indicated in the brief. She admitted to drinking alcohol, she admitted to having sex with her boyfriend afterwards, and she admitted that she delayed in telling anybody about it, which I submit to the court is not uncommon in these types of cases. If there are any other questions, I'll rest on my papers.
Other questions, counsel? Thank you. Case 739, People versus Hemingway. Proceed, counsel.
Good morning, Your Honors, and may it please the Court, Sarah Goldfarb on behalf of Mr. Brandon Hemingway. Unless there are any questions about the waiver of appeal, I'm going to move on to my other arguments.
Please do.
Mr. Hemingway was denied the effective assistance of counsel when his attorney took a position adverse to his motion to withdraw his guilty plea. The defense counsel is certainly not required to adopt a client's...
Counsel, let me ask you this. Now, defense counsel can say, we're not adopting the pro se motion to withdraw, right? The defense counsel is okay to say that. Your concern is when counsel says that there's no grounds for the motion.
Exactly.
That's where the attorney steps over the line and is now advocating in an adverse position to his client.
Exactly, Your Honor, and that's consistent with cases out of the Second Department, People v. Graves and People v. King, where defense attorneys in those cases made similar additional statements about why they were not joining in the client's pro se motion, and that's really where the harm to the client comes, because it was adverse to his interests, it undermined his position before the court, and it was just unnecessary.
I think what the people's argument is, they understand that issue, but they argue for the exception that if the record shows the court was going to deny the motion anyways, in other words, the attorneys taking that position adverse to the client had no effect on the ruling, then it's not a basis for reversal. That's what they're arguing. Well, how do you respond to that? Because it seemed like a frivolous motion. It seemed like it was not going to be granted, no matter what the defense lawyer said. So why would we reverse in that situation?
I think it's hard to tell exactly what the trial court was going to do, unless he came out even before the defense attorney said anything. I think something that a client's attorney says is going to have an effect on the court, and so we shouldn't just say, oh, the motion was going to be denied anyway, so it doesn't matter what defense counsel said against it. I think, defense counsel's statements that, there is nothing here, there's no legal basis, really supports the trial court's opinion already, and so it doesn't lead the trial court to go into the motion to review it at all.
There's nothing in the record that supports anything close to the fact that what Justice Lindy is outlining.
As far as I'm aware, there is not.
What remedy do you think should be imposed here? You're looking for this error. We have another error which the people have conceded on the youthful offender adjudication.
Correct.
Which is a little surprising, seeing that we've been through that before on a prior appeal. And that didn't get corrected for some reason, kind of baffling, but, so it's got to go down for sentencing, or at least for the court to determine YO. But on this issue, are you asking that the plea be vacated, or should we remit it, sign new counsel that won't take a position adverse to his pro se motion? Which one do you want? Which one do you think is appropriate here?
Based on the arguments in his motion, as well as our arguments in the third point of the brief about the ineffective assistance of counsel that was provided to Mr. Hemingway, the fact that nobody involved with the case seemed to understand this court's decision when it remanded the case back to county court, we would be asking that this court vacate Mr. Hemingway's plea so that he can sit down with a competent attorney who has reviewed this court's decision and will take his case back starting from the indictment and review all of that discovery.
And he's getting a windfall there then. The error was, he makes the pro se motion, your client. We have no idea whether it had any merit. Doesn't look like on the surface it may have, but the lawyer took a position adverse, said didn't see any grounds for it. We agree with you. If we would agree with you that that was improper, then why wouldn't we just give him a new lawyer and put him back in the same spot he was when the error was committed? What you want us to do is go back and assume the motion, the pro se motion has merit, get him out of his plea, and now he goes to trial. That would seem the remedy's a little much for that error.
I don't think that this court necessarily would need to assume that the pro se motion had merit. I think trial counsel's statements later on in the proceeding that he explained to Mr. Hemingway that this court only sent his case back for resentencing to put that period of post-release supervision on the record.
Exactly what you'd be provided with if it went back to address those issues. The court would be able to evaluate what it had before it and then ultimately make a determination to allow him to vacate or not. So we'd put it back to status quo with all the information we know right now. I mean, as Justice Lindy's alluding to, or saying, why wouldn't that be the proper remedy? And if the court finds there's sufficient information, then a court vacates it. If the court denies it, it comes back to us again. Not me, but the court.
Right. I think it's really because of those statements that defense counsel made about that he provided this bad advice to Mr. Hemingway, which almost props up that pro se motion to withdraw the plea. It adds additional support to the fact that Mr. Hemingway's plea was not knowing, voluntary, and intelligent because it was based on bad advice about his options that was given to him by his defense attorney and then was echoed by the prosecutor and echoed by the trial court that, listen, you can't bring up any of those other issues. The appellate court has already decided those against you. And so I think that takes you even further than where we are at that appearance.
We have that argument, counsel. Anything further?
Then if there are no further questions, then Mr. Hemingway will just ask that this court vacate his guilty plea and send his case back for further proceedings on the indictment. Thank you.
Good morning. May it please the court, Caitlin Guptill on behalf of the people. In relation to point 2, I would agree with Justice Lindley and Justice Sentra. I don't believe that there is any review of this record that indicates that defense counsel's comments had any bearing or sway on the judge.
I'm not sure that's what we said, but we were, I think, more focusing on what the proper remedy would be here.
Focusing on the proper remedy, we acknowledge that the case needs to be returned to county court for a youthful offender determination. I don't believe that the plea is required to be vacated, but be back before a judge to be heard on his pro se motion to withdraw his plea.
Even though he got bad advice from the judge and from his lawyer.
I
They
believe-
told him the scope that it was sent back from us was remitted to determine one little narrow issue, and that all the issues he wanted to raise in his pro se motion had been resolved on appeal. None of that was true.
2 points in regards to those comments. First, the timing of those comments. I believe that the court's comments regarding why the case was sent back were made after the defendant entered his plea regarding the defendant's avenues to move forward. Defense counsel did indicate that that is what he advised his client, but I believe that that statement is partially true. It was returned for the sole purpose to place post-release supervision on the record. The portion of that statement that was inaccurate was that the appellate division had visited the remainder of his claims. The remainder of his claims on that initial appeal were limited to youthful offender adjudication and the appropriateness of the sentence. I don't believe that those statements rendered his plea involuntary, and I believe that the appropriate remedy would be just to return the case for youthful offender adjudication and to continue to be heard on his pro se motion to withdraw his plea.
We'll take a look at that, counsel.
Thank you.
Case 740, People versus Corey. Also proceed.
Good morning, judges. Craig Cordes for appellant Scott Corey. May it please the
Counsel,
counsel?
can I just ask you, clearly, there's no dispute that he was in custody.
Correct, Judge.
So the issue is, he calls the deputy over. He says, I've been hurt, beat up, whatever. The deputy, if he said, tell me about being beat up, that's interrogation. What he said here, what happened, that you consider that interrogation, and therefore his response was not spontaneous.
That's correct, Judge. I think that when the detective asked what happened, now there's a test required that's clearly set out in case law, and the test is whether under the circumstances that question is likely to elicit an incriminating response.
Right, but on that point, isn't it, don't we need to know what else the officer asked? In other words, the question, what happened, could reasonably interpreted to, how did you get hurt? Why are you in the hospital? The defendant's in the hospital room, the officer's outside. The defendant addresses him first, solicits him, waves him over, and the officer just says, what happened? Isn't it reasonable that the officer is asking, how'd you get hurt? Not, why are you in custody?
Well, I don't know if that approaches the question as we need to. I think the question is, if you have an individual who was suddenly arrested earlier that evening, he was beat up, he's in a hospital bed, he's chained to the hospital bed, he sees a detective across the room who he knows. It's clear from the record that there was real familiarity between these two individuals. And the detective approaches, he says, I've been beat up. So the question is, at that
Let me
point...
ask you this, counsel. So if I understand what you're saying is, if a person with a white coat walks into the room and he's in the hospital bed, and they say, what happened, a reasonable inference might be that they're asking me a medical question. How did I get hurt? A police officer comes in and says, what happened as you're chained to the bed. A reasonable inference might be they're asking about what did I do and how did I get chained.
I agree with that analysis, sir. I think that the question, it's clear from case law, particularly People v. Garofalo, that the question needs to be approached from the perspective of a trained police officer. would it be reasonable to suspect that this man's injuries were connected to the circumstances of his arrest and to the crime that he was alleged of accusing, or alleged of committing?
See how this is a close issue, because but I think as Justice Whalen pointed out, when we're dealing with a police officer asking what happened, would it be reasonable to think that such a question would elicit incriminating information? And I think that's really where the
And is it the people's burden to show that it was spontaneous?
Yeah, absolutely, sir. I mean,
And you don't believe they've done that?
yeah, I mean, I think that if Detective Rivers had walked over to the bed and Mr. Corey said, "I've been beat up," I mean, Detective Rivers could have stood mute and allowed Mr. Corey to continue in his statement, and I don't think we'd have any
Yeah, without the question,
real argument
would have
here.
been spontaneous.
When he asks the question, it changes the analysis, and
But
again...
I think your answer to my question is, even if the officer's question of what happened was not intended to elicit an incriminating response, it doesn't mean you lose. Because once the defendant, instead of talking about how he got injured, starts talking about the crime, at that point, the police officer has to intervene and advise him of Miranda. Because it's not going in the direction, if we're assuming the officer had good faith, he just was concerned how he got hurt. If it's going in another direction, can the officer just sit mute and let him incriminate himself without the benefit, he's in custody, without the benefit of Miranda, or does he need to say, look, wait, before you go there, I have to do this? So that it's possible that you win at the outset or later on in the questioning.
Absolutely, and
The officer's acquiescence to allow him to continue to give details is wrong, in your opinion?
well, I mean, firstly, responding to Judge Lindley, the officer's subjective intent is irrelevant for our analysis. I mean, what he meant to be asking, it's just not relevant. You know, Miranda describes our Fifth Amendment right as precious, basic, fundamental, and so it put in place this prophylactic measure, and it's a simple 4 sentences that, in that instance, are required before he asks any question of this man.
I think we have that argument, counsel. Anything further?
No, thank you.
Thank you, counsel. Case 742, People versus Seymour.
I'll go with it, but, harsh. Kind of foolish.
Good morning.
Good morning, counsel. Proceed.
May it please the court, my name is Marcia Hunt. I represent Joseph Seymour in this matter. The question before the court is whether the trial court improperly denied youthful offender adjudication, and alternatively, whether the sentence imposed was unduly harsh and severe. Joseph was 18 at the time of the incident that was alleged in the indictment. And yes, it was a very serious case. However...
Counsel, you're well aware of, this court has read the record and very familiar not only with the facts, it's not the first time the co-defendant has been there, some of us have been on the panel. What I'm focusing more in on is the application of 720 of the CPL. Did it meet either of those factors? You seem to be mentioning factors that are normally considered in a YO application, but because it's an armed felony, this appears to be, you have to check one of the 2 boxes.
That's correct, Judge, and I think that in this case, both of those boxes have been checked.
Tell us why.
All right, the first one is the mitigating factors in this case that I've cited and explained impacted Joseph's ability to make choices in his life. And I think that the lack of a role model, the lack of support, his upbringing in his childhood clearly had a negative impact on his ability to make correct choices, and impacted the reason that he ended up in the situation that he was in that evening.
But that to me is a factor we would consider not on the 720 specifically. We're looking to a crime, weapon involved, somebody injured, those types of things. 720 is very specific when it talks about what the court has to consider before it gets to the other factors.
I understand that, Judge. However, I submit that the ability of him to make proper choices is clearly a factor that is contemplated by 720. And
720 says mitigating circumstances that bear directly upon the manner in which the crime occurred or where the defendant was not the sole participant in the crime and his participation was relatively minor. It appears from the facts here, it wasn't minor because the officer testified to that there was three or four defendants, all had guns, all had them pointing. We don't know whether or not he's the one that fired the shot, but I don't know if that would be considered by the court as that being a minor participant.
I'm asking the court to consider it in that regard. The fact is, at the suppression hearing, the police officer testified that they had no idea who did the shooting. They were not able to pin that on Joseph Seymour at all.
well,
He was a
let's assume,
passenger in the vehicle.
Let's assume that you get over that hurdle, eligibility hurdle, and you're in the game, and the court has discretion to grant youthful offender, or we have discretion ourselves. And I'm usually open to those arguments. I think I think Justice Nemoyer has written about the development of the brain at that age, and we understand all those issues. And this court generally is inclined to give young defendants second chances. We understand that the stigma of a criminal record stays with you for the rest of your life, and good luck getting into college. You can't get student loans, getting a job. But here, this young man had the benefit of youthful offender, he was adjudicated youthful offender, my understanding, several times prior. He was given YO on a number of offenses. He received probation, another break. He violated probation, sent to jail. He comes out, gets arrested 2 more times, adjudicated youthful offender again, violates probation again. Now he's out there participating in this.
1 week after he was released.
This is not a situation where somebody makes a sole mistake, they feel sorry, remorseful, and want to change their behavior. This guy perceives the granting of youthful offender adjudication as a license to just continue with his criminal ways. And you want us to give him another break, yet another one.
I do, Judge. He was 18 years old at the time of this offense, and honestly, during the period of his incarceration in the Justice Center, while he was waiting for this matter to be disposed of, he took advantage of several educational opportunities, showing that he was making an extreme effort to turn his life around.
He appears when he's incarcerated to be doing the right thing, and as Justice Lindy pointed out, when he's not incarcerated, he's doing the criminal thing.
Judge, sometimes you hit the rock bottom at a different point in your life, and this may be where he did that. And the question is, would it hurt to give him one more chance? A sentence of 1 1/3 to 4 does impose accountability for the act itself, and yet the youthful offender adjudication does allow him to move on with his life in a more productive way.
We'll take a look at that, counsel.
Thank you.
Thank you.
Good morning, Your Honors. Ken Tyler for the people. I won't belabor the facts. I get the sense the panel obviously is always very familiar with the record. The important thing for me, not just for this case, but for future cases is, of course, and the panel recognizes this as well, is not to conflate the ultimate Cruikshank factor analysis on the substantive YO adjudication with the threshold question of whether either of the 2 statutory prongs on an armed felony offense applies. I don't think we get over that hurdle. For those reasons, I'd ask you to affirm. Justice Sentra, congratulations. Thank you so much for your generous time here in court and out of court. Good luck. I hope I get to run into you soon. Thanks.
Case 743 in the matter of Grayson S.
Good morning, Your Honor. Stephanie.
Counsel, if you could hold on just 1 second, please, let people get situated.
Yes, Your Honor.
And before we begin the argument on this case, the AFC is present? Yes. Could you tell us, does your client prefer the pronoun he? Yes. For purposes of this proceeding? Yes. Very good, very good. We'll recognize that, of course. Counsel, proceed.
Thank you, Your Honor. Stephanie Davis, attorney for the appellate. Your Honors, I'd like to address both the AFC's and the department's first argument with regard to the fact that they believe that the notice of appeal was untimely filed. I would like to state that neither CPLR 2103 nor the Family Court Act 1113 authorizes a court to serve a final order upon an appellate by email.
I think we can get right past that.
Thank you.
You're absolutely right. The statute does not talk about service by email. The court has to have done it by mail, so.
And if Your Honor, indulge me just for 1 second with regard to that, I think that both the CPLR 2103 as well as the Family Court 1113 has to be read in conjunction with CPLR 5513 that states that the time starts when the party serves upon the party the order.
Well, the Family Court Act allows service by the court, but it has to be by regular mail.
Yes,
Right.
Your Honor. Thank you. My second argument is that appellate does not dispute the fact that a single incident can form the basis of a neglect. That's not the issue. The issue is whether or not the actions of the appellate on that particular day, that single act, would form.
Recognize that corporal punishment could qualify, but I think your point is that when you look to the record, what proof do we have? What proof of how he struck the child? What proof of what injury, if any, was caused to the child? It appears that the record seems to be lacking in the information. It also doesn't appear to be a repetitive conduct on behalf of your client. So
You're taking my argument.
I mean, that's,
Yes.
I think the record's clear in that. So
Yes, Your Honor.
really-
I mean, certainly what happened on that day, it was not of his making. I mean, you have one child that's outside that's literally fighting with the child of the girlfriend.
Not just fighting, but beating up. Look, I
That is-
agree with
that is
everything.
the-
I agree
that
with
is the wording.
I agree with everything Justice Sentra said. I might even be willing to go, well, we don't know the extent of the injuries here. We don't know if it was a punch or a slap. But even if we did, even if it was a punch and there was contusion or so forth, I'm not sure you lose. You have the son's sister was beating up another family member there at the scene.
Yes.
The son then, this is all over a toy that a small child wanted, and the boy didn't want to give up a wrestling ring, okay?
Yes.
So that's what we're fighting about here.
Yes.
The boy's sister beats up another girl.
Yes.
Causing physical injury. Then the boy picks up a rock and throws it at the motor vehicle, the father's car, and breaks a window. Am I correct?
Well, not only that, but the child goes outside, interjects himself
Yes.
into the dispute that's going on the outside.
Right, so then in response to all
And
this...
picks up a rock, as you just stated.
And then in
and
response,
smashed the car window.
the father strikes the 14-year-old boy, his boy, in the face. I would not be convinced that that's neglect, even if it was a closed punch that left a mark or some injury, under those circumstances.
Your Honor, that was another one of my arguments here, is that none of that appears in the record. We don't even know if the hit was intentional or accidental. It certainly has been portrayed.
It's described in two different ways, as I recall. One was
It certainly has been portrayed as intentional, but the record is silent on that fact.
I think we have that argument, counsel.
Okay, thank you, Your Honor.
Thank you.
Good morning. Jeff Tompkins, here today for the Oswego County Department of Social Services. Just to follow up on the questioning that was just taking place,
I don't think anybody's condoning what happened, what the father did. He lost his temper, and no one's condoning that. The question is whether this single incident, in the context of these facts, rises to the level of neglect. That's really the bottom line.
Well, and I think that...
A single incident can,
Right.
but
And I think...
generally, I think our case law, when we've made such a finding with respect to a single incident, there's usually more. There's usually either a pattern or the victim is vulnerable, perhaps extremely young. We don't have that here. We don't have a pattern here. And we don't have any proof that there was any sort of actual injury. So I'm struggling a little with the neglect finding, too.
Well, I guess I would agree that there could have been more evidence, but from the evidence that was presented, it was the finding that was made by the judge. The respondent, or the appellant, chose not to take the stand, did not give a version of the story. It was only based on basically the statements of the children who were there. I know you indicated...
Your argument, counsel, is essentially that in a close case, and so let's maybe agree that this is a close case, that we should be looking to the trial judge who's there on the front line of the case and relying upon the judge's determination on those findings.
Yes, in that respect, and
the trial judge made a negative inference because of what you just said, that the father chose not to take the stand.
right. And also, as you indicated, sometimes there are other things that the court can rely on. I would point out that this child was not living, I don't believe, with either parent, was living with grandparents for some time, which is always indicative, of some sort of problem. Again, we don't know exactly what it was.
Not necessarily neglect, though.
No.
I don't think we can speculate that the child is...
No, and I'm not indicating that it was necessarily neglectful, but it was not the normal family unit, and the children were residing with
It may be that the record isn't developed enough here for us to get to some of those issues.
Right, and I guess that's what I'm saying, is based on the record, I think that it was an appropriate finding, or at least not error.
We'll take a look.
Thank you.
Good morning, Your Honors. May it please the Court. Susan Maris, attorney for the child, Grayson. At the time of the incident, Grayson was 14. Grayson was living with his grandparents. The father's girlfriend, the father's, I believe, adult daughter go to the grandparents' house and start an altercation, a brouhaha over this wrestling ring that Grayson owned and did not want to give up.
Did they start a brouhaha by asking for toys for the younger children? That's starting a brouhaha?
Well, it somehow escalated. The grandmother's yelling off the porch things. It just was a whole family argument where Grayson's sister...
Where I'm a little confused, you're getting into it all, I think it's more simplistic. We look to the record, we look to see the conduct, we look to see what's proof in the record, what type of hit it was or lack thereof, what type of injury, lack thereof. They could have started a fight. But the fact of the matter is whether or not there's sufficient proof in the record, at least my view, that this rises to the level of the court's determination, no matter what precipitated the problem. I mean, it's that basic to me, at least it is to me.
I think there's clear proof in the record. One is a negative inference. Two is the sister, Grayson, and the DSS witness who interviewed them said the father punched Grayson. Where the issue was, it was either in the head or the face. As this court held in Bayless, you don't need medical attention. An adult man hits a 14-year-old in the head or face, there's pain there. You don't need medical attention. He was hurt. And yeah, it's in the midst of an altercation. Maybe he didn't lie down and say, oh my gosh. But of course, there was pain when you get punched in the face. So I think there is proof in the record. You don't need medical attention. And I think there was a clear case of this single incident and I think they sustained the petition to prove neglect.
We'll take a look, counsel.
Thank you, Your Honors.
Case 748, in the matter of Sloma versus Saya.
Good morning, Your Honor. Susan Maritz, attorney for the child Mia, who is now a junior in high school. She's 16 and a half years old and very clearly desires to live with her father.
Well, Counsel, let's get to this threshold question, which I appreciate you addressing in there. And I noticed from looking at the cases, you've been on both sides where the attorney for the child, whether or not they're standing or lack thereof, and you've seemed to have pointed out that you've been on the winning side and you've been on the losing side of both issues. So obviously the focal point for us, as we're familiar with the facts of the cases, is does the statute provide, does it provide for standing for an AFC to bring an appeal?
Well, I think the plain language of the statute does, because the statute expressly states that the attorney for the child's assignment continues upon the filing of a notice of appeal by the attorney for the child. So clearly, the attorney for the child...
So if the parents reach an agreement and the court agrees with it, the child can bring the appeal himself?
When the parents reach an agreement, is that what you're asking, Your Honor? Those are different facts, and those are not the facts here.
Well, certainly no parent is appealing this.
The father filed a notice of appeal, absolutely. He did not perfect, and he did not perfect because what he told me is he applied twice for assigned counsel and did not hear back from assigned counsel.
But are you saying, I mean, you seem to be saying at one point, it shouldn't, under your argument, it shouldn't really matter whether the father filed a notice of appeal but didn't follow through with it. I mean, the question is simply this: does an AFC representing the individual have a right to file a notice of appeal on the AFC alone? We recognize we got cases where the other parties are involved. This is a case that I think Justice Niemeyer is alluding to. If and I know you say it's not the facts of your case, but if there's a stipulation between the parties, if we say that an AFC has standing, how far does standing go?
Well, it's up to the court to interpret the statute, and what we have is the case law that interprets that statute, and the case law says that when the parties stipulate and they're not aggrieved, the child can't undo the stipulation. That's the case law. Certainly, I would advocate that perhaps this court can go farther and say, when the AFC files based upon the plain meaning and express words of the statute, that the AFC has standing.
Right, so I think you were referring to McDermott versus Bale, I believe, which was a 2012 case that a number of us on this bench, 3 of us were on, and that was a case where the parties reached an agreement on custody. They were both happy with it. The child wasn't. The child filed a notice of appeal. Neither parent did. And we ruled in that situation, the child didn't have standing to appeal. Well, we didn't dismiss the appeal, which is an important distinction. We affirmed it. But we said the child should not be allowed to scuttle an agreement that the parents are satisfied with. But we didn't dismiss it. Are you suggesting, are you arguing to us that children in these types of proceedings have full party status? Or are you conceding that they don't have quite full party status like the mother and father?
I think they do have full party status.
So then we were wrong in McDermott then?
If this court, absolutely, I would argue that based upon the Second Department's case, which clearly says a child has a right. They're not property that someone decides where they go. Their interests should clearly be entertained. And yes, they should.
Their interests are entertained. I think the question, though, is in the example, you know, what this court obviously has struggled with for many years is the question of in the situation where the parents do come to a custody agreement, if the child, whatever age the child is, isn't happy with it, does the child then have the opportunity to undo that agreement by serving a notice of appeal when the custody order is filed?
Your Honor, what I would say is, in this case, that's not our facts.
No, I know that,
So
but
we should make I would ask for a determination on these facts, that the child has standing.
What makes this case, in my view, unique is the underlying issue. Because what remedy would the client have? The underlying issue you have here is ineffective assistance of an AFC, correct?
Correct.
And if the appellant had appealed, he can raise it. You would agree with that? If the father appealed.
If he perfected his appeal, he took an appeal.
So if we find that there's no standing, what we're saying is that you can't have ineffective assistance of an AFC from the child unless somebody else raises it, because the child can. I mean, that seems kind of backwards. You follow what I'm saying? Meaning that the issue would never, they can never be ineffective, because if the child can't raise it and nobody else does, it never gets heard.
Right, so there's another reason to entertain this appeal.
Why the court struggles, you know, I said, with these issues, is because once we say standing, you're saying us, it should be a case-by-case determination. When the facts change, then we address whether or not they should have standing in some and maybe standing not in others.
Well, the big divide is whether the parents agree. So it would just be to custody.
Right, let me say this, in response, Justice Perodato asked you some hypotheticals, and your response is, what my response would have been if I were you is, well, we're not dealing with those facts, we're dealing with this facts, I want you to rule on this, but, and that happens often, but the reason we ask these questions is that a ruling on your case is going to have implications for future cases. So you're concerned solely with your client, we're very concerned about your case as well, but we also have to be worrying about the next case. And what happens if we rule your way in this case? What does it mean down the road? So that's why we ask those types of questions.
So again, I think the distinction would be when the parties stipulate, that would be where you guys would have a different, and perhaps a different analysis, but I go back to the Second Department. And I think if you rely on that case, they say the child has a right.
If the parties stipulated to an agreement and the attorney for the child, on behalf of the child, disagreed with the content of the stipulation, would not the first step be to move at the trial level, to vacate the stipulation, and then get a ruling at that point before it came up to us?
Procedurally, they could object to it, certainly, but once the judge issues the order on stipulation, could they move to vacate? I suppose, I don't know what the grounds would be.
That would be I guess that's the point. The point is, if they had grounds to contest the stipulation, then doesn't that have to be heard below and get the court's consideration before it comes to us?
Possibly. So take the facts of this case. If the parties stipulated to, let's say, joint custody, and that's not what my client was looking for, well, then there's the ineffective assistance of counsel. Of course, the AFC wouldn't have raised that.
Ineffective assistance of counsel in not moving to vacate the order granting joint custody.
Right, not advocating for the client, but that would still have to be before this court, because that AFC...
It seemed to me that the biggest error here was the child's lawyer took a position adverse. We had a case earlier talking about that. I was surprised to see here the child's lawyer was arguing that there was no change in circumstances, which is totally contrary to her client's position. So if there's no remedy for that, then there doesn't seem to be any meaning to the whole right to counsel for a child.
Correct. The child would have had no effective representation.
Counsel, we'll take a hard look at that.
Thank you, Your Honors.
Case 749, Green versus Evergreen Family Limited Partnership.
Good morning, Your Honors.
Counsel.
First of all, I'd want to congratulate Justice Sentra on a wonderful career. Thank you for serving. On to our argument in this case. I represent the defendant appellants. This is a labor law 240 case, and the first primary question is whether or not the work being done
Repair or ordinary maintenance?
versus routine maintenance, which is not covered.
Right, those, and we've had those, I recall a case, my first term on this bench, that I struggled mightily with, and this reminds me of that. I think these repair versus maintenance cases can often be very close questions. They're enormously fact-driven.
Yes, Your Honor. And the undisputed facts in this case demonstrate that this was not an emergency situation like the litany of cases cited by the respondent plaintiff in this situation. In those cases, like Cullen or the litany of cases that followed Cullen, you had a situation where it was an emergency call and they were going to fix something that had been broken, or they discovered something that was broken based upon the emergency call.
But it doesn't have to be an emergency call.
No, Your Honor, it doesn't have to be, but that is the body of case law that the plaintiff respondent is relying upon in support of their position that this should qualify as a repair.
Isn't there proof in this record that this door, this overhead door, was not operational when your client was called to do either the repair or maintenance?
No, Your Honor, there's nothing in the record to support that these doors were not operational. In fact, the record supports that they were.
I thought that, I actually think that, I thought that there was testimony going both ways. I thought the service manager testified that, that the door was not operational.
No, Your Honor, there's...
The record reflected that one door was not operational.
The door at issue where the plaintiff was working...
I don't know, but he said one, he brought him in for to look at the doors, plural, but one door was not operational.
So yes, Your Honor, to describe, this is a 4-bay car wash, doors on either side of each bay, go up and down, overhead doors.
We have 8 doors, but what counsel, the table seems to argue is that it doesn't necessarily turn on whether the door is operational or not. It could be operational, but functional, not functioning well. So in other words, it might be working, but there might be some problems with it. And then that would then fall into repair as well.
Not necessarily, Your Honor. This case is very similar to Esposito, which is the Court of Appeals opinion that addresses this issue. In that particular case, the plaintiff went to address an air conditioning unit that was functioning but making noise, low amps, and when he arrived, he observed that due to normal wear and tear, the belts had been chewed up and needed to be replaced as a result of being used over time. And he was injured at that very moment of attempting to fix the air conditioner by replacing the belts. And the Court of Appeals specifically stated that is routine maintenance. It is exactly like this case, where 2 weeks prior to the accident date, the plaintiff was called to the defendant's location to evaluate what maintenance needed to be performed. No emergency call, nothing broken, simply an evaluation of what work needed to be done to make sure there were no issues moving forward with the new manager.
The work that was ultimately done, how extensive was it? Like, how long did it take to do?
Well, Your Honor, the plaintiff indicates that it took more than 1 day. And the only reason that it took more than 1 day was because the plaintiff's accident occurred. There was not a scheduled multiple-day servicing of these doors. There was a scheduled appointment for the day of the accident to service all of the overhead doors as outlined in the evaluation that was performed 2 weeks before. So, Your Honor, there's simply no case law to support that this would follow or fall as a repair as defined by the Fourth Department's precedent or the Court of Appeals precedent.
Was there any regular schedule of maintenance here? Like a lot of businesses, every 3 months we're gonna oil this, we're gonna maintain that. It doesn't sound like there was such a schedule here, which they say augurs for repair over maintenance.
No, Your Honor, there was no schedule, and no, there's no case law requiring that there needs to be a schedule of maintenance for it to fall under.
It's one factor, though.
It just can be helpful, that's all. But this is like 4 years since they had somebody in there to fix something?
Yes, Your Honor, so that goes further in support that this would be routine maintenance in establishing that these component parts lasted for a significant period of time before they wore out.
Some might argue that the failure to do routine maintenance can lead to requirement to have repair done. In other words, if you wait 4 years to do routine maintenance, then all of a sudden you have a situation where a repair is needed.
Yes, for example, if something broke and your car, good example, you don't get the oil change for 5 years and your car breaks on the highway and you can't operate it. That is exactly what Your Honor is stating. That's not this situation. These doors and this facility was operating without issue. The only reason that the plaintiff's employer was called was because a new manager was starting and they wanted to make sure they could address any preventative issues, so there was nothing that was going to happen in the future.
We're aware of that. Okay, counsel, you want to proceed into the next argument?
Second argument, Your Honor, is that the plaintiff himself testified that he was the sole proximate cause of the accident. He explicitly admitted that he was trained on ladder safety. He explicitly admitted he was the one that evaluated these doors 2 weeks prior. He explicitly admitted he made the decision to choose the ladders that he was using at the time of the accident.
What about the defendant's, I'm sorry, the plaintiff's expert affidavit that says that this ladder was inadequate for the job? How should we factor that into the analysis?
Well, Your Honor, you have the plaintiff's expert disagreeing with the plaintiff himself. The plaintiff's own testimony.
That's a question of fact to me.
Exactly, Your Honor, and that's why we're asking, as part of our second argument, that you overturn the trial court's decision dismissing those affirmative defenses. We're not arguing that we should necessarily win on that, but it at least should be presented to the jury.
Counselor, I know this isn't the facts, but you seem to place some weight or value on the fact that what the plaintiff thought was an adequate safety device, correct?
Correct.
I know these are not the facts of the case. What if you thought it was a bucket was sufficient? We've had many cases where they've stand on a box or an upside-down bucket. Would we hold the same there?
No, Your Honor, because those have not been considered by the courts as a safety device. A ladder has been defined and considered by the courts as a safety device, and the plaintiff acknowledged this was the safety device he was supposed to use.
This safety device, there's no dispute that it failed to provide proper protection to him. The ladder failed in some regard. He was standing on the second highest rung, but the ladder didn't protect him. So where does that leave us? Can it be sole proximate cause when the one safety device doesn't work? Were there other available safety devices at the work site?
Your Honor, to address that issue, first we have to look at what he did with the ladder. So he acknowledged this was an adequate safety device. He then acknowledged he was not supposed to stand on the second rung or the top rung, and he misused it.
That's exactly it. He's not standing on there for any other purpose to try to do the work. And the fact that he had to stand that high on the ladder, of an 8-foot ladder, would indicate that that ladder wasn't tall enough. If he had a 10-foot ladder, he wouldn't have had to been on the second highest rung. He wasn't going up there for anything other than to do the job, and then the ladder collapsed. Stands to reason that another device would have been better for that job. A lift is what his expert says, or at the very least a taller ladder, neither of which were provided to him here.
Your Honor, I don't believe in his affidavit or in his deposition testimony did the plaintiff explicitly state that I needed to stand on that second rung in order to accomplish my work. What he did acknowledge is that if he was standing on that second rung, that would be a misuse of the safety device.
And the accident happened because the ladder tipped over.
Well, Your Honor, we provided a video to the court which shows...
Got the still photograph shots too.
Yes, Your Honor, which shows him stepping outside of the frame of the ladder and the ladder starting to shift, which if you step outside of an A-frame ladder, outside of the legs, the ladder will shift in the opposite direction. That's exactly what happened here. So again, Your Honor, to address your point, we're not necessarily arguing that this case should be dismissed on sole proximate cause, but it at least should be presented to the jury. Thank you.
Take a look at that, counsel. Thank you.
morning. May it please the court. Martha Berry on behalf of Respondent Cross Appellant Bradford Green.
So on the question of repair versus maintenance, does it matter, in your view, whether the defendant was coming out to address this particular garage door or one of the other garage doors?
I believe that the...
Overhead doors.
Right, the overhead, no, yes, the overhead doors. The Court of Appeals has held repeatedly that the inquiry into repair versus maintenance is the overall scope of the work. So it's not just the instance, what the plaintiff was doing at the instant that the accident happened.
So there's 8 doors here. If one was broken, if one needed to be repaired, the others just needed maintenance, and the worker gets hurt on one of the doors he's providing maintenance for, you're saying that's still the overall work is he's doing repair work?
Yes, that would be the overall scope of the work. It is our position, though, that on this door that the plaintiff was working on, that it was malfunctioning, and that is consistent with the defendant's expert testimony. There seems to be no dispute that they were replacing a bearing that was corroded onto the shaft. That bearing had to be grinded off of the shaft with a grinder. The grinder is shown on the floor of the video in the bay where he was working. Defendant's expert, Gordon, has, in his affidavit, says that if a bearing is broken, the door will not work. Plaintiff's co-worker testified that if a bearing is broken, the door might work, but it would work rough. And I believe that's...
I know that's one of the tests. There's so many different factors. I mean, you can make that same argument about changing a light bulb, you know? The light bulb goes out, the lamp doesn't work. Or the light, it doesn't make light. So, but I recognize that, you know, there's lots of case law that says one of the tests is whether it doesn't work.
Or whether it's not working properly, and I believe that's the standard in this department, the second department, and the third department. In St. versus Syracuse Supply, the Court of Appeals distinguishes routine maintenance as involving simple tasks with minimal work, such as what was involved in Esposito, the case relied upon by defendants, which was replacement of air conditioning components in the context of a monthly maintenance check. That is completely absent here. I think the documentary evidence in this case establishes that there was never anything routine about what plaintiff's employer was hired to do at the Precision Car Wash. There are no records that the plaintiff's employer was hired to go out and provide greasing of the bearings, oiling of the springs, checking, troubleshooting, or anything like that. No, they were hired to go out and provide an evaluation of what work needed to be done because these doors had not been worked on in over 4 years. They provided that evaluation and then provided an estimate. And that estimate said, repair job estimate for multiple door repairs. Now, plaintiff's employer knows the difference between maintenance and repair. They provide maintenance services as well.
Well, certainly, the use of the word repair isn't going to be binding on us. I mean, we have to look at the nature of the work and not what word is used in a particular invoice or document.
Absolutely correct, Your Honor. But I just think it's significant that the employer chose the term repair when they would know if they were hired to go do maintenance, one would think that would have been what was on the form. The recent Court of Appeals decision in Healy, I think, is instructive on the issue of what is routine, although that was in the context of cleaning. The court said, work is routine in the sense that it is the type of job that occurs on a daily, weekly, or other relatively frequent and recurring basis as part of the ordinary maintenance and care of commercial premises. And I'd submit that there was nothing about the work plaintiff was performing on the day in question that was the type of job that occurs on a daily, weekly, or other relatively frequent and recurring basis.
What about the sole proximate cause argument?
Yes, thank you. We move to dismiss both the recalcitrant worker defense and the sole proximate cause defense, and we believe that special term properly granted our motion on both of those affirmative defenses. First,
Didn't the plaintiff himself say, there was nothing wrong with this ladder, this 8-foot ladder was adequate for the job I had to do?
the plaintiff testified that there was nothing wrong with the ladder, but he did not testify that this was an adequate ladder for the job he was given to do. He did not elect to use that ladder. That ladder was brought to the job site by his supervisor. The plaintiff has said he would have preferred to use a lift, but there's an extra charge for a scissors lift. If the customer pays for it, they may be able to use a
That's
lift.
what the expert said would be the appropriate equipment to use on this particular job, isn't that right?
Correct. Correct, Your Honor. So it's our position that the defendants have abandoned the argument that the ladder was an adequate safety device. We have our expert who said it was not. They have not addressed that, and
I'm just looking at the plaintiff's testimony, and he was asked specifically, for 10-foot doors, you'd use an 8-foot A-frame ladder. Yes. And then at the end, he was asked, I guess, one final question. Are these ladders sufficient to do the work that you were doing in that particular bid? His answer was, at the time, I thought they probably might be able to do it. He was asked, I think, a number of times, you know, was this 8-foot ladder, was this the ladder that you usually used to do this job? And in your judgment, was it adequate?
And I would submit, Your Honor, that it's not the plaintiff's burden to determine, under 240, to determine what an adequate safety device is. The public policy of Labor Law 240 puts that responsibility on the owner, and in the case of a general contractor, a general contractor. So the plaintiff did the best he could with the ladder that was provided to him.
As to saying he did the best he could, if he climbed higher than he was supposed to, stood on the second highest rung, and leaned over such that he caused it, so is it the device that failed, or was it misuse? Does it make a difference?
With all due respect, Your Honor, the case law holds that failing to follow safety instructions on the use of a ladder is not sole proximate cause. It may be comparative negligence, which is not a defense to a 240 case.
Thank you, counsel.
Thank you.
Cases 750, 751, and 752. Shetler Stone Products versus Town of Marshall.
Vincent Rossi, Your Honor, for the Town of Marshall.
Proceed, counsel.
Of course, the central question in this case is, what is this document really? The April 2013 document. A permit, it seems to me, grants permission. This document did not grant permission, and just, if I can just focus on one particular piece of it. Of course, this document was drawn by laymen in 2013. It wasn't drawn by a team of lawyers. But the first and probably most important provision in it, it says, and this is a quote, noise control by natural barrier, owner to provide scientific documentation comparing quarry activity and ambient noise levels, plan to be provided at owner's expense, and then the key language, prior to the commencement of operations. So the only reason why the ZBA would have asked for the ambient noise versus the noise that's going to be generated by this quarry would be to assess whether that particular quarry was suitable in that particular place. And the undisputed proof in this record is it was never provided, and nor were any of the other things that the zoning board asked for, dust control plan, public safety plan, so on and so forth. Now, we have that is substantial evidence, I say, for the ZBA to decide that this wasn't a permit. Plus, we have the best, the witnesses with the best knowledge of what this document really was were two of the people who signed it, Jasek and Gilly, both of who, not just out of the blue, but supported by contemporaneous minutes from December 2012, January, February, March 2013, in which the board continually asked Shackler for these items, and he never provided it. So that's substantial evidence. And I think the key error below was that the court below decided this based on what she would have decided if she had been on the ZBA, and that we know is not the standard. Now, assuming that I'm wrong about this and that it was a special use permit, the injunction that was imposed in this case is way too broad and goes for way too long a time on these facts. Now, just, if I may, the trial court, the special term, issued an injunction, and I should say, Your Honors, that this injunction was the fruit of the judge's mind. There was no settling order on notice, so the judge just created this based on what she thought was correct. And she ordered that the town and its enforcement officer are permanently restrained from regulating and or prohibiting mining operations at the Shackler Quarry, as these actions that have been taken by the town are superseded and unenforceable under the state statute. Now, everybody knows that the DEC state statute does preempt, to some extent, the town's power to regulate. Namely, the way the limestone is extracted from the ground is the DEC's province, not the town's. But the town permit here, what Shackler says is the permit, there's an hour of operation limitation in it. There's a maximum number of truckloads, and critically important, and something that was made real in the court below was there was a perfectly sensible, reasonable requirement that said that the natural berm and foliage that separated the quarry from the road was to be left in place as a noise barrier. Now, that doesn't have to do with the way that the limestone is extracted. So after the case was, the Article 78 proceeding was returnable in December, in January, the Shackler bulldozed away the berm, tore out all the trees to the extent of about 100 feet back from the road. The photographs, there are color photographs in the record at the back of Volume 4, showing what was done. So I made a motion to renew to the court saying, well, you can't deny the town any right to control this activity, and submitted that to the court, and that application was denied. And forgive me, I'm getting a little out of order. Going back to the injunction point, so when I made a motion to re-argue and raise this question about the overbreadth of the injunction, not only does it totally prohibit any regulation, but it's permanent. Now, the permit that Mr. Shackler has expires in October of 2013, 2023, both the DEC permit and the town permit, if it really is a town permit. And so I argued to the judge that, well, you've eliminated all the town's right to regulate, and we should reconsider the language of the injunction. And Judge Clark says, this is at page 2129, I never intended to take away the town's right to talk about or regulate ingress and egress, dust control, hours of operation, and the other things that the town certainly has the right to control. So she acknowledged that those things were within the power of the town. And then I proposed a couple of pages later, Your Honor, can we submit a proposed order to sort of settle the order on notice? to work out these details of what the injunction should say, and she started to give some alternatives, but then when the lawyers for Shackler objected, she said that's off the table. So she refused to consider narrowing the breadth or the time period for which the injunction would apply. And if I may, I got accused of all sorts of misconduct in this case because I represented the neighbors before I represented the town, which I don't think is a meritorious criticism. There was never a motion to kick me out of the case. But I just wanted to emphasize that, certainly because I was, I hope, a vigorous advocate for the town, that's not a basis for criticism, but when this case was about to be heard by the ZBA on September 22nd, Shackler made a motion on order to show cause to stay the hearing. And Judge Clark heard that motion the day before, on September 21st. And in the colloquy before the court, the judge said, well, you know, should Vincent Rossi be representing the code enforcement officer and the ZBA itself? And I acknowledge that that's not an ideal situation. So I promised the court that I would provide no advice, have no communication with the Zoning Board of Appeals, and that colloquy is not in the record, but what is in the record is my affidavit filed afterwards, in which I say, and this is at volume 4 at R1104, quote, as I promised the court at oral argument on September 21st, I refrained from giving any advice, direct or indirect, to any member of the Zoning Board of Appeals when it deliberated on the appeal from the code enforcement officer's stop work order. And there's also in this record affidavit from Mary Ann Marsh and the other two members of the ZBA who voted that I had no communication, they never spoke to me. So there isn't any basis for saying that I tainted the quality of justice below. And
You should wrap up.
I have nothing else to say, Your Honor.
Very good, thank you.
Peter DiGiorgio, I represent the proposed interveners in this case, and although my issues are limited to whether there should have been an intervention as a matter of right or by permission, they are significant. I mean, zoning laws are made for people, they're made for the neighbors, and the people who were the proposed interveners were the neighbors of this quarry and are directly affected by its activities.
Well, one of your concerns, though, as to why you felt you should intervene was because your clients were fearful this appeal wouldn't be pursued?
It's one of the issues that...
Hasn't that been resolved? The appeal's been pursued, and we've heard, so there's no need for their intervention.
Right, but at the time the judge making that determination, that was unknown. It was unknown when they're making the determination whether there was going to be a settlement of the case. Perhaps the town felt that the mine could operate with certain limitations that could affect the neighbors, so the court wouldn't know all this. Ultimately, yes, and it's outside the record, but the appeal almost didn't happen. But it got here, yes.
Clients, how are your clients not being adequately represented otherwise in this proceeding? Why do we need to bring you in?
Okay, well, first of all, I think anytime you have a town that represents globally everyone's issues and neighbors' issues, you have a money issue, okay? The neighbors may have independent wealth to, like, for example, exhibit number 45, which was an expert report on the noise. The neighbors could have combined to financially put forward their own expert to rebut that determination put forth by the plaintiff. The town may not want to spend the kind of money to protect this particular area. They may have other zoning battles they have to go after. So we have that issue. The town, like I indicated to Justice Nemoyer, may want to settle the case. So the matter was being litigated to the fullest extent by Mr. Rossi. We agree with that. But these people who are directly effective should have the ability to make their own arguments. And what's unfortunate here is that the trial court ruled on the motion to intervene at the same time that it ruled ultimately on the merits. And I know, and I believe this is adequately set forth in the brief, in the reply brief, but should the neighbors now want to seek some legal redress, they have the problem of collateral estoppel. It was marked all in the papers how the town and the neighbors had similar interests, a conflict of interests, but similar positions. Well, now, crafty lawyers down the road might say, some of the issues that were decided with respect to this permit have already been litigated, that the permit is valid, the permit exists, and they're bound by privity by collateral estoppel, and I cited a number of decisions. So I believe the briefs adequately reflect all these arguments, and I believe this needs to go back to allow for litigation, to allow for the neighbors to litigate these issues. They're the ones living with this pounding day after day.
We'll take a look at it, Council.
Thank you.
Thank you. Good morning. May it please the court, Michael Fogel for respondents. We think it's clear that the lower court was absolutely correct to reverse the ZBA's decision in this matter. Based on the standard of review in the Pell case, the court's role is to review the ZBA's decision and to determine whether it was supported by substantial evidence. We think it's clear, and the lower court certainly did, that the decision, not only was it not supported by substantial evidence, it wasn't supported by any evidence at all. In fact, the lower court noted that the evidence in the record that a special use permit was in fact issued was quote, unequivocal and incontrovertible. It's obvious that the decision was a result of just community pressure from a very small minority of people who were against the mining operation, and also was preceded by the actions of a code enforcement officer that had an obvious conflict of interest based on personal and financial issues, which preceded the issuance of the stop work order and the notice of violation that was before the Zoning Board of Appeals, which the lower court, I think, appropriately found demonstrated a deliberate abuse of authority on behalf of the code enforcement officer. At the end of the day, the record was complete with references to the special use permit being issued in 2013, all along up until the time when the neighbors basically put pressure on the town to interfere with my client's operations. That includes actions taken in 2013 by Ms. Jasek and Mr. Gilly, who not only approved the special use permit, but also signed it. So
That was also true in 2019, where the ZBA acknowledged that they issued the permit in 2019.
that's correct. So the Zoning Board of Appeals, and its continuing, as part of its continuing jurisdiction over the special use permit, after doing some additional homework into whether the special use permit contained conditions that were superseded by the mine land reclamation law, obviously first affirmed that, yes, made it very clear, and there was no doubt at all that they had issued a special use permit in 2013, and then went a step further and specifically decided that the conditions contained in the permit, which appellant mentioned, were superseded by the mine land reclamation law, so in essence, excising those conditions from the permit. And neither the 2013 special use permit or the 2019 resolution by the Zoning Board of Appeals was challenged within the applicable 30-day statute of limitations, and we submit that both of those decisions are final and binding, and were in fact relied upon by my client.
Can I ask you a question that was touched upon?
Yes.
The special use permit that was granted in 2013 was for a period of 5 years.
Well, actually, Your Honor, it was granted to run concurrently with
to the DEC. And the DEC, it took years for them to come around.
Well, and Your Honor, that has a lot to do with just the process of applying for a state mining permit in New York State. We do a lot of mining. We represent clients all across the state in obtaining mining permits from
So it's a slow-moving process. The DEC
slow-moving
finally
process.
came across in 2018. Do I have the date?
Correct. After a comprehensive environmental review under seeker, which the town agreed that DEC should be the lead agency, which under seeker is the agency primarily responsible for ensuring that environmental review is completed, and the town participated and commented through that process as an involved agency.
So the special use permit, 5-year from 2013, started running in 2018 when the DEC granted its permit. So this is all, it's going to run out at the end of this year?
Well, the DEC permit's renewable. DEC allows for mining permits to be renewed for 5-year terms. My client certainly intends on renewing the permit, which is in his affidavit with the papers. So we submit that as the DEC permit is renewed, so is the town special use permit.
That's the next battle. But we're not deciding that one today.
Very good. Counsel, anything further?
Just on the intervention, just briefly, we think the court was correct in denying intervention. First of all, the Article 78 proceeding was obviously on the very narrow issue of whether the code enforcement officer acted appropriately in issuing the stop work order and notice of violation. So we challenged that ZBA decision. That's a very narrow issue. It doesn't involve anything other than a challenge to municipal action. I mean, I think it's worth noting that the attorney for the interveners below noted in the record that they were not going to add anything additional to the town's arguments on the Article 78 proceeding, that they were just essentially going to say, me too. So there's obviously no need for intervention. Their whole argument was really hinged on this idea that, well, the town may not appeal, we want to have a seat at the table in case the town doesn't appeal. Obviously, we're all sitting here this morning, so that concern went away. And I think it's really important to note that the neighbors were trying to assert 5 separate and discrete private nuisance actions, which they obviously can still have their day in court. They can file a private nuisance action, which, 2 years later, they still haven't done. So we think the trial court was fully within its discretion in denying intervention to the proposed interveners. And if there's no other questions, I'll rely on my brief, and thank you.
Thank you, counsel.
Thank you.
Case 753, Miller versus Bavard. Proceed.
Good morning. May it please the court. Thomas Givas from Pappas Cox. We represent the appellant in this case. Basically, what we're talking about here is a 1984 deed to the Millers from Mirage Labs, which contained an easement. Basically,
It's really straightforward here. Is it an easement? Is it a license? So what we do is you look directly at the deed or the documents to see whether or not there's any ambiguity. This is where I think the crux of the argument begins. Is it whether or not, if there's ambiguity, you may have a license. If there's no ambiguity, what does it say? So that's
Right.
really, I think, the crux of your argument.
Basically, Your Honor, what we're saying is, in the interpretation of a deed or an easement, you look at, one, if it's a deed, that is one argument that it's an easement. Two, you look at the wording. In this case, the wording was grant or convey, heirs or assigns, forever.
Well, heirs and assigns were to the means and bounds description. Did it say that for?
It also says it at the end, Your Honor, I believe. In this case,
But in the specific part granting the use of this particular recreation area, the grant was to the grantees, wasn't it?
but then, Your Honor, it goes down, and towards the end, it says, this is all for everyone.
But isn't the focus, if it's ambiguous, and didn't the judge in his summary judgment motion below find that it was ambiguous, and no one at the time understood the significance of that finding?
No, I believe what he said was that he basically said, I don't see any termination language in here. The wording looks like an easement, and...
But then he later said, referring to even to your own expert who said the language is less than clear. The court said if it's ambiguous, there's a license. You're contending the court was wrong in saying it was ambiguous.
I believe, Your Honor, what the court said was it should go to trial. In other words, if the court cannot look at it and it needs to go and look beyond the document, then you need to look at the intent of the parties. And if you look at the intent of the parties in this case, by surrounding circumstances, all of the surrounding circumstances indicate that this should
So
be...
you don't believe the law says if it's in ambiguous language, it is a license?
I believe the judge has to look at what was happening, the intent of the parties. Those were the cases that we cited.
Yeah, Willow, Texas is the main case there,
Yeah.
and you're looking at it as if there's a provision of a contract that's ambiguous, then you go to parole evidence. But I think what is being suggested is that under Willow, Texas, is a different rule, is that if it's ambiguous as to intent, then you don't go to a hearing on parole evidence. It's just deemed to be a, license. But the language that concerns me for your position is the use of the premises are subject to the sale of the same by the grantor. What possible meaning could that have other than the Millers could use it unless and until Edith sells it?
Well, Your Honor, I think what happened later was the property was actually deeded into a trust.
Correct.
And that accepted out the entire Miller deed. So after that, we believe that there is really no right to terminate. And in
But
addition...
would you agree, when it was written, and you know the file better than I do, but when the easement or the license was granted to the Friends from Edith, it said you can use a recreational area in these other areas, and other people, by the way, and others could use it. And then it said subject to the sale of the same by the grantor, i.e. Edith. Is that correct? Doesn't that indicate that Edith wasn't giving the Millers an unlimited lifetime use of the...
I would have to check to see whether it said by the grantor. I believe it said subject to sale. But
my concern is, when we're dealing with it, and which I thought, I never knew this, usually it's usually interpreted against a drafter, but on this provision in the cases, it's interpreted, once again, as my colleague pointed out, anything ambiguous is interpreted as a license. Well, then why would there be a need to have any hearing or any proof put in? Because if it's not ambiguous, okay, the court can rule. If it's ambiguous and you need something outside to explain it, that to me makes it ambiguous, and the rule appears to be if it's ambiguous, it's a license.
One judge, we were saying, one, the rules of interpretation.
Okay.
All of those are in our favor.
Okay.
Two,
But I thought
there was
you can't interpret if it's ambiguous to start with. If there's no finding, if here the finding is ambiguity, the law seems to say then it's a license.
And
you say let's argue about what it means.
Yeah, basically, the explanation that we gave the court was that this was not, the actual sale occurred, to the Millers occurred well after the deed. I mean, you had an 84 deed, I believe the sale was in 85, and I don't think the deed actually even got recorded till 87. So, I mean, in a simple sense, it just says, hey, if we're not going to give this, if you don't buy it, forget it, But what we also were saying is that a lot of these other circumstances point to the fact, all of the people involved indicated, or that are left, seem to indicate that, yes, this is an easement, it was supposed to be an easement. It was used that way for 30 years. Basically, what we have is something that was, all the deeds to all the other parties involved said subject to easements and restrictions of records. So, everyone else got the easement. There was no, as the court noted, there's no termination language in there. So we believe that the easement continued. All the surrounding circumstances say that. Even like the the answer and a lot of the paperwork involved in this say, hey, look, yeah, it's an easement.
We'll take a look at that, counsel.
Okay. Thank you, Your Honor.
Good morning, Your Honors. Roger Bradley, appearing on behalf of respondents Gretchen and Eric Bavard in support of an affirmance of the order and judgment of Justice McCluskey. I believe three considerations clearly point to affirmance here. I requested 15 minutes of oral argument, but I see the depth of analysis already given by the court, so I can shorten it considerably. I believe the three relevant points are precedent, which we hear so much about these days and is so important. Finality of transactions, so that the parties know at the time a transaction is entered into, what it means, not to be determined by depositions, what the words mean 30 years later with hearsay and after the fact matter. And I think there's a significant term that I hadn't planned in my oral argument, but I picked it up off of the comment of Justice Lindley, and that was windfall. Because at the end of the day, in addition to the issues of ambiguity and certainty of transactions, both of which are directly challenged by appellant here today, what's involved is getting through all that. Appellant seeks a windfall. Now, my clients, the Bavards, have property located on the waterfront, and they paid for it. Mr. Sly, who will comment shortly, his property is on the waterfront, and he paid for it. Now, Mr. Miller's property is not on the waterfront. If he wanted it, he could have paid for it, presumably, but he didn't. What he wants is a windfall, but not a mere windfall, but a windfall that comes from at the expense of the Bavards, who have the right to enjoy the property, and the Struthers. As far as the interpretation of the court in West Tex, in this court, New York Land Development, certainly no better than to instruct or suggest to a court how they interpret their own decisions. But I would just mention a couple of quick things from the record that I think clearly fit in with what is likely to be the interpretation, I think, of this court from precedent. Number one, unrestricted use. This wasn't a case, it's a policy of the state of New York, but what the appellants propose left Mrs. Reichschlaub with something other than unrestricted use because she couldn't sell her
So as I
property.
understand, you're pointing to our decision in 2018 in New York Land Development where we says the writing must establish unequivocally an intent to grant a permanent right. And you don't believe the language in the deed does that?
The language in the deed, if it has any language of permanence, it's the language subject to sale, which shows it's not permanent. Ambiguity is found by the court, as suggested by respondents, as suggested 2 or 3 times by appellant's own expert.
So if the court found it ambiguous, then it's a license?
Absolutely.
Okay.
But in addition, Judge, I think, and I'll again truncate my argument, but I think a very serious consideration that's been raised by appellant is that, well, you have to look at the surrounding circumstances and to comment on the analysis made by the judge or justice. The law is to be applied, not the law that appellant's expert used to get us here today, because that's really why they're appellant, namely, you construe it against a drafter. Well, this isn't a contract. It's a sale of realty as to which the Court of Appeals, and I believe this court, have laid out their own special rules and said, Justice DeMoore, if it's ambiguous, it's a license. That's the only way we can have certainty, protect the policy of the state in unrestricted use. That's the law, and that's what should be applied
We
here.
have it, counsel.
That's all I have, Your Honor.
Thank you.
Thank you.
May it please the court, Robert Sly for respondent David Struthers. You know, it helps to understand what the Miller family thinks they have the right to do, and that is to use other person's property. And for example, in Mr. Struthers' case, a dock that he built subsequent to the 84 deed, they think they have the right to go down and use it, and tie the boat up to it, and sunbathe on it. That's why we made a motion for summary judgment at the time that said that the use of the said premises are subject to the sale of the same by grantor. Mrs. Rochlab sold that to Mr. Harvey, who then sold it to Mr. Struthers, and we made a motion for summary judgment that said, look, that's what this means, is that you don't get to, she sold it. It's not forever. Right. We lost that motion for summary judgment. So what happens is we take our papers, we throw them in our red weld file, we throw it on the trial calendar, we get ready for trial, whenever that comes. That's when we had what I call a eureka moment. I could have had the V8. Subsequent to that summary judgment motion, we learned that this court had ruled in the New York Land Development Corp case that if it's ambiguous, it's a license. That was the basis of our motion prior to trial to limit proof, and the judge said, you're right. When I said it must mean something, I was really saying it's ambiguous, and those of us who now are respondents win the case. And I thank you for your attention.
Thank you, counsel. Case 741, People versus Allen. Proceed, counsel.
Good morning, Your Honors. Amy Hollenbeck on behalf of the people. The people's position in this case is that the lower court wrongfully granted or granted in error the CPL 33030 motion filed by the defense seeking dismissal based on the presence of juror number 9 on the panel that rendered the conviction. The people's position in the lower court, and my brief goes into this in detail, is that the defense waived any objection to the presence of this juror.
It wasn't like the juror held back when initially asked the question about relationships.
Correctly.
Right? Hand was raised.
Correct, and also...
The question was there, and nobody questioned that particular juror.
Nobody asked her, and she also put, I believe, on her juror questionnaire that she was related to an attorney or knew somebody who worked in a law office. I can't remember the exact wording of the question. So she put it up front twice, and nobody asked her. Now, the lower court came to this conclusion that they should dismiss or that they should vacate by finding a mode of proceedings error. Again, I would submit to the court, there's no mode of proceedings error here.
Right, so your argument is that under 330, reversal has to be required by an appellate court for the trial court to grant the motion.
Correct.
And it wasn't required here. What, if you're right on that, is there... I think everyone agrees that this juror was not qualified to be sitting based on her relationship.
Well, I don't think she was disqualified. I think she was subject to a cause challenge, and if that challenge had been made, I think the question may have come up. It wasn't the attorney who was standing in the courtroom prosecuting the case that she was related to. It was the district attorney. Correct. I think that the lower court probably, following the idea that you should lean toward caution in those cases, would have granted the cause motion.
That's not my understanding. My understanding is if there's a challenge for cause, then you can't rehabilitate, and you can't purge it by saying you can be fair. You're out. But my point is, if you're right here that it wasn't a basis for a 330 sub 1 granting, is there any avenue of relief? The defendant goes to a 440. Or can they raise it on appeal? In other words, is there any avenue for this problem? Because there is a problem here. When the first cousin, once removed, of the district attorney is sitting on a jury, and he goes on Facebook and talks about it, that's a problem.
I think it's a potential problem, yes, and I think but I'm not necessarily sure that she is disqualified. There's a difference between implied bias and actual bias.
Remedy.
The remedy, I think, would be to vacate the judgment, return it for sentencing, and the defense could file a direct appeal, making basically the same argument they made here, and this court could determine procedurally whether there was error or
we
whether
could reach
there's
it in
an
the interest of justice.
Yeah. which the lower court can't do. I mean, our position, if that all happens, it's a little perspective, is we don't think there's an interest of justice problem. We think there's a method to challenge jurors, that a juror who is not challenged for cause or is challenged and a cause is not granted that should have been, must then exhaust their preemptories. I mean, there's a whole process here in the law, and if those steps are not followed, I don't think there's a presumption that there's fundamental unfairness.
All right, so he should go back.
I think
and
it has to be demonstrated.
He should be
and-
sentenced, and gets
Right.
sent to prison, and then he files an appeal and perhaps a stay application. That's the route, not the 330 route.
Yes, absolutely, because I don't think there's any basis here. This court would not have been required to dismiss under the law. This court may have had the option.
We answered, right?
Correct.
Were we required? Very good.
Correct. And also, we don't see anything that would disqualify this juror other than that issue on the cause challenge for a possible issue on implied bias. Thank you.
Thank you, counsel.
Good afternoon. John Sarando on behalf of the respondent. The juror number 9 was disqualified as a matter of law to sit on this jury. And implied bias, like indelible ink, never comes off your shirt sleeve or your blouse sleeve. It's just, there's no way around it that this juror should not have been on the jury. So how did the juror become...
What do we do with the idea that the juror raises her hand? In other words, we do have those cases where the juror, later it's found out, the juror did not respond correctly to the questions, and that's a whole different issue. But here, counsel, we have a juror that, as counsel points out, twice, both on the form and by raising her hand, says, look, there's maybe an issue here, and there's no questioning, not by the judge and not by counsel.
The question, when you look at the statute, the questions as to qualifications are to be asked by Judge Hafner in this case. Judge Hafner, in his decision, specifically indicated that I made a mistake in my questioning of the jurors. And his questioning masks the error of the questioning.
Is that what makes this, in your view, a mode of proceedings error?
Yes.
The problem I have with that is that there was an opportunity for the defendant to object. And generally, not in all circumstances, but mode of proceedings errors usually involve a situation in which the defendant doesn't have an opportunity to object or raise the issue with the trial court so that things can be fixed.
This is the most basic function of a trial, is a fair and impartial jury. This was a subversion of the required voir dire process. It's a mode of proceedings error because it attacks the essential validity of the trial. The verdict is tainted. There's no two ways around it. You cannot say that this verdict is not tainted because the juror, contrary to what the prosecution wants you to believe, should not even have been sitting in the courtroom.
That may be so, but, I think our view, I don't speak for everybody, but there's a procedural issue here. The question is whether this issue should have been decided on a 330 motion or whether it should come up on appeal following a judgment.
I think the trial court answered that by talking about the effect on the verdict of the implied bias. This is an unusual situation. You've got the implied bias, which can't be waived. Implied bias cannot be waived.
As you can see from the questions from the court, I don't know if there's a lot of disagreement as to some of the statements you're making, but the question we struggle with is the proper procedure. And that's what whether or not procedurally this 330 was a proper avenue or is a proper avenue. I can say this to you, it doesn't seem fair that if it is a valid issue, if we can't address it at this point, and we have to send it back, and a person has to be sentenced, and a person is doing state prison time, just to come back to us and say, okay, now it's properly before us, we can address it, that doesn't seem to be fair either.
Because if it comes back before you, 5-zip, it's implied bias,
Okay.
and it has to be, but I think that you feel we can step outside of the procedural setup to reach that, and we should do it. I think the way the judge wrote the decision, I think he did, because there's not many times that the judge, a trial court judge, falls on his sword and says, I made a mistake. This is not the way the jury selection process should be conducted. And when you look at the statute, that responsibility for relationships is with the trial court. It's not with counsel. That's because he's to determine, he or she is to determine the basic qualification of the juror to sit in that box. And that was subverted here by the judge's improper questioning. So in the unique circumstances of this case, we would submit that it is a motor proceedings error, as he indicated.
Very good. Thank you, counsel.
Thank you.
Don't go far.
No.
Case 746 and 747, Derek Johnson versus Kenya Johnson.
I always thought things looked better from over there.
Proceed, counsel.
John Sorrento, attorney for the appellant father. This is an appeal from 2 orders of dismissal on a violation petition and a modified violation petition where the father seeks sole physical and legal custody. Recently, this court had modified the order to allow joint legal and physical, and father now has the legal, and the mother, well, regardless. The father filed a detailed amended petition, which listed very numerous events, some of the same type of things, not the same things, but the same type of things that resulted in this court's prior decision to grant the father primary physical residence. And the court, in its decision, when you look at its bench decision, admits or indicated that the father proved his petitions. But then
It seems that the court kind of conflated, kind of indicated, well, they had problems before the last decision, they got problems after the decision, but it's apparent that the reason why the original court did what the original court did was apparent that their relationship and their communication skills had gotten better. But it's clear from this record that subsequent to that, the communications gotten worse.
they deteriorated terribly. And taking the child because it's, quote, misbehaving to the police station, not telling the father that the child is in the hospital. There's numerous things that I'm sure the court is familiar with, and I'm not going to read them all. But in the end, he said there was a failure to establish a change in circumstances. and a change in custody would not eliminate most of the issues, but we submit that a change in custody would submit most of the issues. I mean, you've even got a situation here where the mother started out for a relocation way back when, and she shipped everything to North Carolina that she has, and now the child with her is sleeping on an air mattress, and there's a cardboard box couch in the house, and I don't know what else my client has to do, but go into, it's the only thing he can do is go into court and say, look, this is what's happening. And the court in this case says, yes, that is happening, but, and we submit that that is a sufficient change in circumstances to allow for the change in custody that we seek. The deterioration of the relationship is continuing, and it's not going to get better.
Yeah, it seemed that the relationship got better just as the court case earlier was heating up, and then as soon as it was resolved,
she went back to the way she was.
Yeah, the miscommunication or lack of communication started happening all over again. Okay.
I don't know if we can afford to keep going back here.
I think we have the argument, counsel.
Thank you.
Thank you, Your Honors. My name is Scott Otis. I'm here on behalf of DeMarcus. DeMarcus is now 9 years old. It's the second round of litigation and appeals regarding my client. I've represented him since he was about 4. I appealed the current order on his behalf, along with Attorney Sorondo. The trial court judge acknowledged that he would not have awarded joint custody in this case if it were a de novo proceeding. Among the only things that both parties and I agreed upon at trial is that split physical custody is not good for this child. And the judge agreed in his decision and orally to the parties that the current situation is not healthy for him. So why leave it like that? Mom has long wanted to move with this child to North Carolina. She shipped all her possessions and the child's toys there before the first trial judge denied relocation several years ago. And in the long time since, the record shows a long pattern of her continuing to try to coerce that result, her relocation, even asking a DSS worker if they could, quote, trump the judge to authorize relocation. She told one of the child's medical providers that she just needs someone to help her move. She has left her and all of the child's household goods and toys in storage in North Carolina for all the years since, living with my client between motels and a small barren apartment, using cardboard boxes as furniture and a blow-up mattress to sleep. It's really not fair to this young child to have to live half his life that way because his mother doesn't like living in New York. Over the course of the years I've represented him, he has developed a strong preference to live with his dad full-time and visit his mom on alternate weekends due to the adverse experiences that he's had at mom's, which are amply present in the record. His father has a spacious, great home with all of the child's siblings. They all get along wonderfully, and they're an extremely close-knit family. And young DeMarcus has to brace himself every time the new week comes and it's time to leave again. The trial court judge admonished the mother for her enduring bad parental behavior, much of which has already been discussed and outlined in the briefs. I'd rely on my brief for the rest, Your Honors, and ask the court to reverse and modify, giving sole custody to dad with every other weekend to mom and all the other provisions remaining. Thank you.
Thank you, counsel.
Thank you.
Mr. Strano,
before
not on a case, but
Before the court adjourns, I'd like to put some remarks on the record in regard to our honored guest. During my tenure before the Fourth Department, I've been fortunate to have the opportunity to appear before excellent appellate judges on the Fourth Department, Judge Delvecchio, Lawton, Lowry, Hayes, DeJoseph, Carney, and now finally Centro. And I just hope that X, Y, or Z follow in their footsteps. It was a pleasure to see Judge Centra mature from a young CLA to someone who is excellent as acting as justice presiding. His treatment of counsel and litigants was always polite and understanding. You know, you talk about a judge, is a judge a liberal or a conservative or this or that? Judge Centra decided the case before him based on the record without any predispositions. On behalf of all of the attorneys who have had the honor of appearing before you, thank you very much, Justice Centra. It has been a pleasure, and enjoy your new career. Thank you. Thank you, Judge Rowland.